Hello again, it's Georgia Personal Injury Trial Attorney Jack Clay, and today I want to talk to you about what happens when you're hurt and you realize the other side has insurance company and you think that's all you need in your case. We get a lot of phone calls where people tell us that they're hurt, the other side had insurance, but that's only part of the story. I'm going to talk to you about the rest of the story during this discussion. Thanks for joining me. First, just because somebody who harmed you has insurance does not mean that you have a good case. Oftentimes, clients do not understand that you have to prove what we call liability, or that somebody is responsible for causing harm to you. Insurance only covers cases in which a plaintiff or a person who's injured can prove that they were hurt by somebody else's negligence or by an intentional act. Just because somebody has millions of dollars of insurance or they're a large corporation does not mean that they're liable for anything if harm comes to you if you cannot prove in a court of law that they're responsible. Second, proving liability is critical in all cases. You can't just rely upon the fact that you were hurt either on somebody's property, in a car or truck wreck, or in some other way, and that they have a lot of insurance. The reason for that is insurance often is inadmissible in court under what we call the collateral source rule. So the other side can keep out evidence that they have $1 million in insurance or that they have no insurance for that matter. Third, just because the other side or the person or company that harmed you has insurance, they'll get a lawyer by virtue of having that insurance that's paid for by the insurance company in all cases, regardless of fault. What this means is that you're not going to be able to just go against somebody without a lawyer if they have insurance and have an easier time trying to prove your liability. They're going to get a lawyer, and typically the lawyers that defend these cases are competent. Fourth, there are exceptions. For example, many insurance policies have medical payments coverage that cover you on somebody else's property. Unfortunately, this medical payments coverage just pays for your medical bills. It doesn't pay any of the other types of damages, such as loss of use, pain and suffering, and other types of things that we seek in cases. Also, this amount is usually small, ranging from $1,000 to $5,000, although it can be more. So in essence, I tell people we're back to square one. You have to prove that somebody else actually caused harm to you and not just that they have insurance. And finally, our office is here to help you whether you, a friend, or a loved one has been injured and you have questions about your case or a potential case and whether or not you can bring it and how you can prove liability and how we can help you do that. Thank you for joining me.